afternoon. My presentation today will deal with the European Union Directive establishing minimum standards on the rights, support and protection for victims of crime. We will talk about some of the background and also some of the content of the directive and what it will mean for in practice for victims of crime. Looking at some of the background and the reality for victims in the European Union, there are around 75 million people who fall direct victim to crime in the European Union every year. If we also take account the friends and family of people who fall victim to crime, the real number of people adversely impacted by crime in the European Union is likely to land somewhere between 200 and 300 million people. So it's an enormous amount of money. In addition to the emotional strain and suffering of victims of crime, there's huge financial cost to the European Union as a whole. If we take into account the cost of employers, the states, looking at how long victims take time off work following victimisation, the European Commission has estimated that the real cost of crime lands somewhere around 230 billion euros every year. With such an enormous amount of people and such a big impact of crime in our European society, it's very important for the European Union to take proactive measures to ensure that people can access support and protection in the aftermath of crime. More and more people are also travelling, studying and living in other countries than their own, so there is the responsibility for the European Union to ensure that the right to movement is respected and that people are safe travelling within the borders of the European Union. If we look at why the directive is actually taking place at this time, there are some background details that we can clearly identify. The first is the failure of the 2001 EU Framework Decision on the standing of victims in criminal proceeding to fully ensure victims' rights were enforced across the European Union. Following its entry into force in 2001, the framework decision has not been successfully implemented, and in fact not a single EU member state has actually successfully implemented the framework decision and giving victims access to the rights contained within. The Lisbon Treaty, which came into force in December 2009, provided the legal basis for the European Union to develop clear minimum standards for victims' rights. The directive itself aims to establish harmonised minimum standards to ensure that citizens have confidence that the same level of rights and support and protection will be provided irrespective of where in the European Union the victim lives or where the crime takes place. This cannot be sufficiently achieved by member state action alone, which is why the European Union felt forced to take actions themselves to ensure that member states have confidence and trust in each other's criminal justice systems. So looking at the content of the directive, as I mentioned, it establishes minimum standards that are legally binding across all EU member states. I have chosen some of the rights contained in the directive to give you a clear picture of what it actually contains in practice. Many of the rights we recognised from the 2001 Framework Decision on the standing of victims in criminal proceedings, but some of the rights of the directive are also new. The first part of the directive I want to mention is the actual recital, number 19. It states that a person should be considered to be a victim regardless of whether or not an offender is identified, apprehended, prosecuted or convicted, or regardless of any familiar relationship between the perpetrator and the victim. In practice, this recital sets the tone for the directive. Member states will have to acknowledge that victims are victims regardless of whether or not the victim has reported the crime to the police or whether or not an offender is identified. Victims have the right to their independent status and recognition, and that does not have an impact on the accused's right to be seen as innocent until proven guilty. Looking at the objective of the directive, it has a clearly stated objective aiming to ensure that all victims of crime receive appropriate information, support and protection, are able to participate in the criminal justice proceedings and are recognised and treated in a respectful, sensitive, tailored, professional and non-discriminatory manner. In practice, this objective means that Member States will have to ensure that services and rights are available to all victims of crime and not limited to particular groups of victims such as domestic violence, victims of homicide or young victims of crime. Although these groups of victims require assistance and support, so do other groups of victims. So it's a very horizontal objective. Looking at another right, the right to information, which is one of the key founding rights in the European Directive. In order to access any other rights, victims have to be aware of their rights and how to actually access them in practice. The Directive right to information strengthens victims' right to information compared to the previous legislation. It clarifies that from the first contact with the criminal justice system, the victim should be informed how and where to report a crime, how and where to access support services, how and under what circumstances they can access compensation, legal aid, protection, and many other rights. There's also the right to information regarding any cross-border assistance, the contact details regarding their case, and also where victims can turn to complain in case any of their rights are not being fulfilled in practice. Once the judicial process has started, Member States also have to provide victims with ongoing information. That includes case-specific information regarding any particular areas of their case, any decision ending the criminal justice proceedings and the reasons why that decision was taken, any final judgment of a trial and any background information regarding that particular sentence, time and place of trial, and also information regarding the release of the offender. So those are very case-specific information that the directive also provides for the victim. The victim should be able to understand the information, and if and when required, translation and interpretation should be provided free of charge, depending on the victim's role in the criminal proceedings. In practice, victims' rights to information means that Member States will have to make arrangements to actively provide the information. It doesn't specify how this could be done, so in many countries the criminal justice agencies in contact with the victim will provide the information. So the police will provide the initial information, and throughout the victim's journey through the criminal justice system, the different agencies will complement and add further information. Another option is for Member States to set up a one-stop shop or a single victim agency that provides all the information, liaising between the victim and the criminal justice agencies. So the specific setup is down to the individual Member States to decide. The directive simply confirms what information victims have a right to receive. Another important right I want to mention is the right to access victim support services. The directive strengthens and amends the right that we saw previously in the 2001 EU Framework Decision. The article also clarifies the kind of support that should be available and highlights that victim services should be free of charge, they should be confidential, and they should be acting in the interest of the victim before, during and after any criminal justice proceedings. As a minimum, services should be providing information about the rights of the victims and how to access the rights, emotional and psychological support, financial and practical assistance, advice relating to the risk and prevention of secondary victimization or repeat victimization, and also, of course, information and, if required, referral on to specialised victim support services. In practice, the article means that Member States shall ensure that all victims and their families can access victim support services. It doesn't highlight who should deliver it, so it can either be governmental or non-governmental organisations. And support should be provided in a variety of ways depending on the needs of the victim. Support should be given regardless of whether or not the victim has reported the crime to the police. However, the directive does highlight that the police in many ways is optimally placed to inform the victim of the possibility to support. And therefore the directive includes a requirement on Member States to facilitate the referral of victims from the police to victim support services. And I just want to highlight this particular point. The right to referral is extremely important, and it is the best way for victims to get routine access to victim support services. The lack of referrals is the biggest barrier for victims accessing support in the aftermath of crime. The right to protection is a right that, again, we've seen before, but it's strengthened and amended throughout the directive. It highlights victims' right to protection in a variety of ways, including protection from repeat and secondary victimisation, intimidation and retaliation, but also emotional and psychological harm, and protection of the dignity of the victim when giving evidence. The directive has introduced a very interesting article looking to individual protection needs of victims of crime, and it has introduced the requirement for an individual assessment to identify any specific protection needs of victims. To determine whether a victim is at a particular risk of secondary or repeat victimisation, intimidation and retaliation. The assessment should also look at the range of specific protection measures that may be required to actually meet and cater for these needs. The individual assessment, in accordance with the directive, should particularly take into account the personal characteristics of the victim, the type and nature of the crime, and the circumstances surrounding the crime. In practice, this article puts a requirement on Member States to identify as soon as possible whether or not there are any specific protection needs, and to also develop specific protection measures to meet and cater for these needs. The last article I want to mention today regards training. The directive clarifies that training, both generic and specific, should be made available to professionals working with victims of crime. Police officers and court staff should be required to undergo training, and training should also be made available to lawyers, prosecutors, judges and anyone else working with victims of crime. The level of training provided will be dependent on the level of contact with victims. So professionals who work very closely with victims should be required to have undergone further training. The aim is to ensure that professionals can deal with victims in an impartial, respectful and professional manner. So to summarise, the directive establishing minimum standards on the right, support and protection of victims of crime, they are minimum standards. Any member state wanting to go further and provide stronger rights is more than able to do so, and it is encouragement to ensure that member states actually rethink how they engage with victims, making sure that they meet the needs of victims in the most appropriate manner in the aftermath of crime. The EU Directive strengthens and amends many of the current rights, as we've seen in previous legislation, such as right to information, right to access support services and right to protection, for instance. But it also introduces new rights that we have not previously seen to advance the rights of victims in the European Union. That are things like right to an individual assessment, the right to facilitate referrals between the police and victim support services, and also the right to have a decision not to prosecute reviewed. The directive itself was officially published the 14th of November 2012. It has a 3-year implementation period, so by November 2015 every EU member state will be required to have transposed all the rights into their national legislation and providing the rights in practice to victims of crime. Improving access to support, right and protection for victims of crime is a fundamental cornerstone in ensuring we have an area of freedom, security and justice within the European Union. Victim Support Europe look forward to working with the EU institutions, any partner agencies and any other person interested in working with victims of crime to ensure the new rights provide tangible improvements for victims across Europe and beyond. Thank you.